Hey everybody, got some first appearances for you today. I got 2 out of Detroit and 2 out of Thurston County. Enjoy and let me know what you think.
Gentleman in the white shirt. That's you. Gentleman
Yes, ma'am.
in the white shirt. What's your name, sir?
Anthony Ziggler.
Mr. Ziegler, this magistrate in charge today here on criminal matter, case number 240-458-0001, sir. You have an attorney, and it's Anthony Taiwan Ziegler, sir?
Yes, ma'am.
Okay. Counsel Reagan, you're representing Mr. Ziegler?
Yes, Your Honor, right on behalf of Mr. Anthony Ziegler, waive the formal reading stamp duty. He's been advised of his rights, Your Honor.
Thank you. I'm going to enter a plea of not guilty. Court date is September 18, 2024. Pre-trial in front of Judge Bryant. Mr. Ziegler, while this case is pending, you are not to have contact with the North Keith Smith. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Further, you're not to possess any firearms or any other dangerous weapons. And further, you're not to go back to the residence on Toll Bridge while this case is pending. Do you understand those bond conditions, sir?
Yes, ma'am.
Okay. All right, Counsel Ragland, go ahead, ask the bond, please.
Yeah, if you were asking for a $50,000 cash bond, he's able to post bond. We're asking for home arrest at a different location. Very assaultive matter, Your Honor. The complaining witness buys groceries for his mother. He goes over to the area, the house where she lives. I'm not sure if this is a boarding house or what, but this defendant opened the door, started making threats towards the complaining witness, and he said, "Let's go." And with that, he started punching him in the face, and the complaining witness said at least 10 times, pushed him off onto a bench and off the porch, I believe. Shoulder and dislocated shoulder from the incident. The officers, when they arrived, they observed that the left side of his face along the cheek was swollen. The upper and lower lips were swollen and bleeding from multiple locations. His right shoulder appeared to be noticeably lower than the left, and it caused him, the complaining witness, pain when he tried to move that. The defendant is currently federal probation supervised release, Your Honor. Per lien, Mr. Ziegler also has access to drugs or weapons. He's a convicted felon with prior assault to do great bodily harm, less than murder, felony weapons, possession by a felon of a firearm out of 6th Circuit, felony CCW out of the 8th Circuit. He's got an extensive record, assaultive record. There's never a reason to assault someone like this, Your Honor. Maybe, but there didn't seem to be a problem except for this man bringing groceries over to his mother. He is an extreme danger, Your Honor. He's got a violent history. And we're asking for the $50,000 cash surety with tether home arrest. Thank you.
Got a question?
Yes.
The prior convictions, is that from 1998?
Well, there's one of them from 1998, but there's a number of them prior to that. And he's also on federal supervised release now. So I believe
he's on federal. What is the charge on the federal case?
You know, Your Honor, I couldn't find it. Sorry.
Okay. So I see 2006 looks like out of 6th Circuit, Oakland County, 8th Circuit Court, CCW. Counsel Reagan, go ahead.
So obviously, you know, we know that my client has some prior history, but it's in the past, Judge. He's working every day, got a child on the way, he's living with his wife. Judge, you know, obviously the way this is written, it's not written, you know, quite like it actually happened. So, you know, I don't want the court to read this and say this is actually what happened. This is one side of the story. Now, we know it's going to be a lot more to it. He's being supervised right now, Judge, as Mr. Ragnar says, on federal probation. He has a tether, Judge. What's
the probation? What is the conviction?
It's a RICO situation, Your Honor. So it's
RICO
not
situation. Is that involving any type of assaultive behavior, Counsel Reagan?
No, not to my knowledge at all, Judge. You know.
Okay.
So he's on tether for that, Judge, and you know he's being monitored So, Judge is working every day. He's being monitored by his federal probation officer. He's supporting his family. We have one side of the story, Judge. He's not going anywhere. It's not a flight risk. He's not going to go back near this person on Trowbridge. He's staying somewhere else. He's going to go do that. So I'm asking the court, Judge, I don't think a cash bond is necessary, only because I think the monitorization in the federal case lets us know exactly where he is at all times. So I'm asking for the personal bond, Judge, and the no contact provision with this complaining witness. Obviously, these are allegations. There's more to it than actually what is being stated in this complaint, Judge.
Thank you. And court has heard the representations on both sides. Council Ragland, unless you have something new to tell me.
I was just going to tell you about the search warrant, the rifle and other ammunition.
You don't need to tell me, counsel. Like I said,
Right.
if it was anything new, I can
Thank you,
read
ma'am.
that there was a search warrant done. There was items dealing with firearms. And the thing is that even if he's not on probation, RICO matter or not, until he acquires his rights to possess firearms or ammunition, he's not allowed to be around them, possess them, purchase them, sell them. And it's kind of hard that
Sorry with that misdemeanor.
somebody did not. No, kind of hard that somebody did not.
Right.
Council Reagan, court is talking. Thank you.
I'm sorry, Judge. I
Kinda
apologize.
hard.
I apologize.
All right, kind of hard that I know that the investigative report can be one-sided, but it can also be both-sided information from both sides. But what this court is concerned is that the complainant suffered some injuries, okay? And while it's rare about somebody hurting themselves, it doesn't appear that this is that situation. So somebody got injured. There was injuries in this matter. So even if Mr. Ziggler was on or is on, okay, some sort of the tether, and that's what he's on, correct, Council Reagan?
Correct, Judge. Correct.
So the tether doesn't change. It doesn't prevent him from committing or allegedly committing offenses. Okay, and that's the allegation. So he's on probation, he's on tether, he's accused of committing, in this case, a aggravated assault. And it's not enough that somebody allegedly is slapped or anything, but there are some serious injuries where, like either a dislocated or a broken shoulder. So let's see, anything else? And the assaultive, that is from 2006. He may have been placed on probation. He may have been incarcerated. I don't know. But assault with intent to do great harm, less than murder. Okay. Court uses clear and convincing evidence standard. Okay. In terms of when it's entertaining a monetary bond. And then even in this matter, this court does believe that Mr. Ziggler, he is a danger, not only to the complainant, but to the community. He's going to have a cash surety bond of $10,000. I'm not going to put him on a tether. I don't think that's going to help. But with that being said, counsel, this is an unaffordable bond.
Yeah, Judge, we just like a bond redetermination here, correct?
Okay, no problem. That means, Mr. Ziggler, it's this Friday, August 16, 2024. You're going to go in front of either Judge McConigal or Judge Williams, who's going to look at the bond amount and bond conditions. Do you understand that, sir?
No, ma'am.
Hey, so Mr. Ziggler, since you don't understand that, let me say this again, okay? Court date is September 18th. That's a pretrial in front of Judge Bryant. Your bond is right now $10,000 cash surety. It's my understanding it's unaffordable. So that means you're going to get another court date this Friday in front of Judge McConicle or Judge Williams, who will look at the bond amount and bond conditions. If they think that it should be changed, they will change them. Do you understand that part?
Yeah, but this is on the record.
Everything is on the record. And just so you understand, Mr. Ziegler, because everything is on the record, I will caution you as to what you're going to say that you could incriminate yourself regarding this case. Your attorney, you have a great attorney, Counsel Reagan, and so you will get another shot at the bond amount and bond conditions. Do you understand that?
So I can't put nothing on the record.
You can, but your attorney, Counsel Reagan, will probably caution you not to say anything in reference to the alleged facts.
You want to talk about your heritage? What exactly do you want to say?
There you go.
He's a Native American. Mr. Ziegler identifies as a Native American judge, and we just want to make that part of the record. He is a Native American.
Okay.
Yeah, as a Chickasaw and Choctaw Nation, and the Cherokee, we have our own constitution and our laws and bylaws. I just want them to be adhered to or a part of this hearing, further hearing, so that way I can be, judged accordingly, and not according to, the United States Constitution, which says that, a sound-minded body, a Caucasian of 21 years or older is citizens. I don't go by that Constitution. I go by my Chickasaw and Choctaw and Cherokee Constitution. I just want to let that be known. I'm Cherokee by blood. I can prove it. I'm not African. I'm not none of that. So I just want to put that on the record. So when I get treated fair, I just want to get treated fair. That's all. I don't want this to be like history.
Thank you, Mr. Ziegler. Everything is placed on the record. Thank you, and your attorney will bring it up on Friday also. Good luck. You can step aside. DDC, I'm going to hopefully do a hospital arraignment. Detective White. The gentleman at DDC, please stay silent.
Yes, ma'am. Can you hear me okay?
I can, ma'am.
Okay, I'm here
I
with
didn't know who it was when I saw Hotmail.
Yes, ma'am.
Okay, all right. We have the gentleman at a hospital that has a blue cap on his head. What's your name, sir?
Billy Gerard King.
Thank you, Mr. King. I'm Magistrate Chartea. The case number is 2405-880901. You have an attorney. Go ahead, counsel.
Right, on behalf of Mr. King, waive the formal reading, stand mute. He has been advised of his rights.
Thank you. I'm going to enter plea of not guilty. Court dates are August 23rd, 2024, probable cause conference, followed by preliminary examination, August 29, 2024. Both matters are in front of Judge Giles. Mr. King, while this case is pending, there is no assaultive or combative behavior on your part. Do you understand that, sir?
Correct. Yes.
Okay. All right. Counsel Vincent, are you here on behalf of the people?
I am. Thank you, Magistrate. Steve Vincent, P 71917.
Go ahead, sir.
Oh, thank you. We're going to be asking for 20,000, 10%. We're also going to be asking for a tether as well as a curfew. Just to highlight the particulars here, Judge, and this particular incident just happened a couple of days ago. Police called, the defendant's ID'd as the offender here. They attempt to try to arrest him. He runs away, tries to jump over a cement wall or something. And then he does it unsuccessfully, allegedly breaks his ankle. I think that's why he's in the hospital right now. And then he continues to resist, I'm sorry. And the police have to tase him. Now, that probably to you, Magistrate, wouldn't constitute the cash bond that I'm requesting. But here's the thing. He's got two other cases going on, one of which is going to be going up for redetermination tomorrow based on a capias off of a bench warrant that was continued yesterday in front of the chief magistrate. And that has to do with, I believe it's an assault charge. It's an A and B that stems back from December of 23. he's got multiple failures to appear in that.
What's the bond on that?
I believe that's $500 cash or surety, and that's going to be
Okay.
heard in front of, if Judge Williams is taking the bench tomorrow, in front of Judge Williams for redetermination.
It's a
Oh, he
malicious.
has another pending case?
I'm sorry,
So he didn't
Matt.
say anything. Okay, you said pending cases. So one is assault and battery from December
Right.
2023, $500 cash surety. Is there another pending case?
There is, yeah. He was arraigned yesterday as well for an offense date of May 23rd of 24 for a felonious assault. And allegedly, this incident occurred at a gas station where this defendant ended up taking some type of object and tried to assault a patron over at the gas station. All because allegedly that patron had asked him if he was good.
What's the bond on that?
On that one, he was given a $25,000 personal with a tether. So, Judge, if we look at, the totality of things here, this case in combination with the other cases that are going on, I mean, it's the people's position that, he's a danger. He's got multiple assaultive cases. He resisted arrest here, goes so far as to, breaking his ankle, trying to get away from police officers. And then, we have the flight, and then we have the dangerous component of it too. I mean, flight, previous capiases and all that. So respectfully, Judge, we're going to be asking for that 20,000, 10% tether curfew.
Oh, man.
Council Reagan, go ahead.
Judge, I think the A and B case may be an MDP case. The misdemeanor is a $500 cash bond from a few years ago. But regardless, Judge, that's a cash bond that was continued, as Mr. Vincent said, for tomorrow redetermination. He had the 20,000 personal with the tether already from the FA yesterday. So this bond, I'm asking for 20,000 personal, Judge. I don't think he needs two tethers. I think that my client, I don't know the circumstances if he jumped the gate, broke his ankle. I know it was probably pretty painful. I don't know how his reaction was, if he was squirming, if he was, I don't know what happened exactly, Your Honor, but I think that it's a situation where I think you could give a personal in that case. Just he doesn't want to have contact with the police. I think we're looking at this from a case-by-case standpoint. It's an R&O. I'm asking for personal.
So just a question for Council Vincent. In this case, was there any assaultive behavior against any of the officers?
In this case, we would be emphasizing the flight. I don't think that, and trust me, if he would have been assaultive against a police officer, I probably would ask for 10 times as much. This has to do with flight, Judge. I mean, he's trying to get away from police. He's skipping cases, and that is an A and B case. I have the case number. So
we got a misdemeanor, $500 cash surety going to bond redetermination. We have a felonious assault, $25,000 personal bond, GPS tether that is not going to a bond redetermination. Am I correct?
Correct.
you are absolutely accurate. Yes, Judge.
Anything else new that I need to know, Council Vincent?
I don't know. Let me check my notes. I got a full page worth of stuff here. No, I think I covered it, Magistrate.
Thank you. Court uses clear and convincing evidence standard when it's entertaining a monetary bond. We start off with a personal bond basis. In this matter, nothing to indicate, yes, he's running away from the police. Nothing to indicate that there was any assaultive behavior. Yes, running away because he had at the time, it appears there was a warrant out for his arrest. One is misdemeanor, the other one is felonious assault, felony. On the felony, personal bond, misdemeanor, he's got $500 cash surety, and that one was a failure to appear. Is that correct, Council Vincent?
Yeah, I think it was either the second or third time he failed to appear. He had forfeited either one or two previous bonds that he posted. But yes, Judge.
DDC? Oh, no, it's not a DDC, this is a hospital. Detective White,
Yes, ma'am.
can you tell
Yes.
me, does he have a tether on him?
No, ma'am. Wait, let me check. I gotta feel your ankle.
Oh, no, magistrate, he was
He
given
just-
the tether yesterday. I'm sorry.
I was given tether yesterday. All
Yeah.
right, so I'm not gonna go with that. I'm gonna give him a $50,000 personal bond. Okay, I'm gonna let the judge, whether Judge McConicle or Judge Williams, deal with the misdemeanor matter. I will say this to you, Mr. King, you violate in this case, come in front of this court, bring your toothbrush, because you're gonna be looking at a high monetary bond. Do you understand that, sir?
Yes, yes, indeed.
All right. That concludes the arraignment of Mr. King.
Magistrate, I hate to do this to you. Could you just repeat the dates on that? I'm sorry.
Sure, August 23rd, August 29th.
Thank you.
And Mr. Swenson, are we ready on Ms. Archambault?
Yes, Your Honor.
Okay, we had a missed pretrial. And do we have an explanation for the missed pretrial?
Your Honor, Ms. Archambault is unhoused and doesn't have a phone. She does apologize for missing court, but it's very difficult under the circumstances. I did discuss taking the bus to court. It's right off the bus line, and she said that would be an option for her. This was I believe, the first pretrial that she missed. I'd asked the court to consider releasing her with another pretrial date, give her one more chance.
All right, so Ms. Archambault, tell me or give me some reason why, if I let you go, you're more likely to show up the next time than you did the last time.
Because this time I plan on trying to get into detox, getting clean.
Okay. When did you last use?
About 3 days ago.
Okay. And you having withdrawals while in jail?
Yeah.
Okay. And are you going to use as soon as you get out?
Like I said, I've already got information to go see about some detox. Medical
Right.
detox help.
Yeah. Yeah. Having the information is one thing, acting on it's another. And, you know, I know it's a struggle, but you can't, you're just keeping yourself in this cycle by, you know, continuing your use. And you're the only one who can break it.
I know.
Mr. Sharp, city's position on release.
Thank you, Your Honor. I think the warrant amount is 2,500. City wouldn't object to a reduction, but we believe some bail is necessary here. Ms. Archambault presents with 2 active warrants at 2 different jurisdictions. Additionally, the reason we're seeing from the county jail, and the city would assert that it's likely the only reason we're able to address the warrant at all. She's booked in on a new charge. City's not leaning on that as a bail basis and asking the court to determine probable cause. I don't have the report yet. I'm just pointing out that she's in that county jail on a new booking. Otherwise, I don't see a reason why we would believe we could address the warrant. So 1,000 is the request.
All right, thank you. And it looks like a felony charge, is that right?
The roster says burglary second, Your Honor.
And she will be seen at 2:30 over there, I believe.
Okay. All right, there are 2 active warrants. We have a new charge. I do think some bail is warranted, and I think Ms. Archambault was being honest when she said it's more her drug use that's keeping her from meeting her requirements. So $500 cash or bond, and Ms. Archambault, I want you to clear those warrants out of Olympia and Aberdeen. That's an additional condition here, and I'll set a new pretrial for you.
Your Honor, could we set her to next Tuesday? I don't think she's going to be able to post that amount.
No.
I'll take a little different approach. I'll set it to the 2 weeks out to the 26th. And if you're ready to go with something on the 19th, you can ask to have it put on that date.
Understood.
All right, Ms. Archambault, we'll see you on the 26th at the latest, otherwise perhaps next Monday. Thank you.
Okay, so my bail is 500.
$500 cash or bond, and if you post it, then you have to clear the Olympia warrant and the Aberdeen warrant, and you can't use. So let's be real clear about that, okay?
Yeah.
Yeah, just understand that. If what you do is post and go back to using, then, you know, the whole calculus changes. All right, thank you.
Thank you.
And Nisqually, your name, please. Sir, Nisqually, your name?
Brian Lynn, hi, Your Honor.
Good afternoon.
Good afternoon.
Your Honor, if I could help the court here a bit. It looks like on September 27th of 2023, the court imposed a 30-day sanction. I think one or two options were authorized at the time. No proof that that was ever done, and that's the basis for the warrant. City would recommend having him serve that time now without options.
Thank you. Yeah, I'm going to come to you in a minute. I'm just looking at the docket information on the case, Mr. Lynn.
Thank you, Your Honor.
You're welcome. All right, Mr. Lynn, go ahead.
So on that day, there was no option. There was no way I can do the things that you guys asked me. I've tried to comply with everything. As you can see in my history report, everything's been complied with. The paperwork did not allow me to do anything. I've tried numerous times. I've been down to the CLAC court, tried to turn myself in. I called multiple. The court clerks there actually tried to help me get on EHM, but the paperwork that I received only says that I went to court on September 27th. If you look through my history, I've complied with everything you guys asked for, and I would have complied with that as well, and there were an option for me to comply. I've been to the courthouses, been to the EHM places. The paperwork does not allow me. Neither place takes without paperwork. I've talked to Ms. Langley. She sees the case. I have not been doing anything but being above approach and handling everything. And
So,
Ms. Langley?
Your Honor, one of the things, and I don't know if it's clear from the docket, that he did on that last date, he's filed his proof of the victim panel, which looks like it was the last piece of what he had to do other than some fines that are left over. I wasn't at the hearing. I don't even know why, a sanction was imposed when in fact he had done everything, and it's in the court file. And then as he's explaining, he got a copy of the JNS. He tried to set up BHM, and I don't know if the whole situation, but he wasn't able to do it. I'm really wondering, now he's back in the jail. I'm kind of wondering, he's done everything. I'm not sure how many consequences he needs to keep paying at this point. Thank you.
All right. Amy, will you print up the docket text for me for Mr. Lynn? It's starting the day we received the Victims Impact Panel, which is the 7th of December, because it doesn't show, we didn't enter that we received it.
Your Honor, I'll point out to the court as well, that wasn't the only issue. There's also the no insurance ticket committed July 5th of 2023, and that's a mandatory 30-day sanction.
Okay. We'll get to that. Right now, I'm worried about why didn't the docket tell me that Mr. Lynn had actually done his Victims Impact Panel. So I'll move on to Mr. Lynn's problems in a minute. Right now, I'm dealing with the court's problems. All right, so Mr. Lynn, I think what I heard you say was that on the sentence that was imposed last September, giving you those mandatory 30 days, which the judge had to do, there was no discretion on the judge's part. The judge did check the boxes for electronic home monitoring or day jail. And what's the story? How come you didn't get electronic home monitoring or day jail?
So my paperwork does not show that. And when I was trying to turn myself in and get EHM, they could not see any of those. Does that make sense? And it's been this problem since I've been released. You know, because when I first got released, one of the stipulations was what's called interlock and something, and I had no vehicle. So I was trying to purchase a vehicle to complete the last part of that. Does that make sense? I complied with everything they said, and even then, I told them I'm trying to purchase the vehicle right now. I'm trying to finish my last piece.
Yeah, okay. But that,
I don't know you guys have moved in this state, and I'm just literally just trying to comply with everything you guys are asking me to do.
All right. Gotcha there. Because you had that no insurance ticket, the law required the judge to impose 30 days. And the judge did what the judge had to do, which is impose the 30 days. Judge made you eligible for electronic home monitoring or day jail. I have no idea why those services reflect that it wasn't checked, because I see that it was checked. So the ignition interlock is a separate, that's not why you're here today. You're here today only because of the insurance ticket and the 30 days you have to do. We have no discretion about that. So hold on a second. I see you want to say something, just so hold on. I will indicate that our information didn't show that you had completed the victim's impact panel, but I look in your file and I see that you did. So we will correct that and we'll make sure you get credit for that. And then the issue becomes the mandatory 30 days, and there's nothing I can do to waive that mandatory 30 days. I'm going to sign a new judgment and sentence. And once again, I'm going to give you the opportunity to serve those 30 days on electronic home monitoring or day jail. And I am checking the boxes. So yeah, go ahead.
Can I please have the paperwork with that? That's why I wasn't able to do those things. The paperwork just shows that I went to court on September 27th. It did not say anything about EHM or jail time. So I went to the courthouse to try to tell myself that they wanted the paperwork. The court clerk could not provide it. That's what I'm saying.
All right, and I have it. I have it in front of me, and it shows.
And it's the same with the EHM. The victim's impact.
I told you. Okay. I'm not going to argue with you. It shows the boxes checked. Why you got a copy that didn't have the boxes checked, I don't know. The paperwork that is in your file shows the boxes checked. That's all I can tell you.
No, I understand. Thank you, Your Honor. Because I'm trying to do everything. I've been compliant with you guys the whole time. And I'm still being compliant. I'm still on probation. I'm still doing what you guys asked.
Okay. All right. So sit tight and we'll get this squared away. All right. So I've done what I indicated I was going to do, which is I've reimposed those same 30 days, which you have to serve. I will give you credit for the 3 days you've already served. So that brings it back to 27 days that you owe on that 30 days. And I will let you serve that either on electronic home monitoring or day jail. I'm going to order you released today, and you have until the 30th of August to begin serving the remainder of the 27 days. So before you walk out of the jail, talk to Lacey about signing up for their day jail, or you can go figure out how to get on electronic home monitoring. And you're welcome to check in with Ms. Langley about how you do that. but I have authorized that once again, and you have until the 30th of August to start doing that. Okay, last thing, go ahead.
I have just two questions though. One, where would I get my paperwork?
The jail's going to get, they're going to have you sign this in a minute.
Okay. And secondly, Mr. Sharp,
No.
day jail, can I ask what that is? I'm not from this state, so I don't know what I just
What's
wanna
the
know.
question? Ask me, just ask me what the what's the question?
What is day jail?
That's just where you report into the jail in the morning, you work all day, and then they let you go. You don't spend the night there. But it's only if they have it. So you have to check with Nisqually and see if they have it.
Okay. Okay, thank you, Your Honor.
Okay, so you're going to go out, tell the officers we're sending the sentence form, and you're going to sign it. And I'm looking at it now. The boxes are checked, and it gives you until the 30th of August to start serving those 27 days.
Yes, yes, Your Honor.
And if you can't get on EHM or day jail, then you have to begin serving days in jail by the 30th of August. So either sitting where you are now or doing electronic monitoring or doing day jail. Okay?
Yes, yes, Your Honor.
All right. Good luck. Thank you.
Thank you, guys. Do I leave?
Yeah, you're all done. And just, they'll have you sign this form. So tell them you want to make sure you get the form that has all that, and you can look at it when you get it. Okay?
Yes, yes, Your Honor. Thank you, guys.
All right. Mr. Travino, you missed a hearing in October. What's the story there?
When I got released, they didn't give me my paperwork, so I didn't know where I had to go to court for it. I called the Lacey police station, and they told me to show up to the Olympia courthouse. And when I did, I wasn't on the list, so I literally did not know where to go to court for that.
Okay, give me your cell phone number.
Okay. It's 360-926-0646.
All right, thank you. Reason I ask is we will send you in the future texts to that phone a number of times saying, yo, you have court.
Okay.
So if you don't get anything else, you're going to get the text. And I wanted to make sure you do not miss court.
Yeah, I do too. I would like to make that court date.
And Ms. Langley, it looks like you're attorney of record.
I am, Your Honor.
All right, Mr. Travino, do you have Ms. Langley's phone number?
I don't, but I can get it.
And they should have an information sheet out there for Ms. Langley.
Okay.
Make sure you get that because it's your job to get in touch with her, not her job to track you down.
Okay.
Mr. Sharp, anything from the city?
Yes, Your Honor, thank you. So this is a $2,500 warrant that he's booked in on. I point out that it's the second warrant on this case. He also failed to appear about a month before the last one and was PR'd when he came back on that warrant. So as for why we're able to see him and address the warrant today, it looks like that's probably because he was booked in on a new set of charges with Yelm. It looks like he was seen Friday by that court. Court found probable cause. I think he was released. With that warrant background here and new law violation is a violation of release conditions. The city's asking for $1,000 bail. We believe that's going to be necessary for his return.
All right, thank you, Ms. Langley.
Your Honor, he's not in any position to post bail. I think with text messaging, that's going to enable him to come to court. He's not going to forget or get confused. He is at least staying, although it's not a permanent address, he's found a place to stay in the Yelm area. So I think the court can be optimistic about him returning if he's released today. Thank you.
All right, I do see that you were released on Friday in the Yelm case.
Yeah.
All right, I'm going to give you an early test here. You're going to, I'm going to put you on the calendar for 2 weeks from today at 8:30 in the morning. You need to be present. If you're not, then Mr. Sharp's words will ring true that you're not reliable on coming back, even if we send you text reminders.
Okay.
Now, order your release. You're coming back on the 26th of August at 8:30 in the morning.
Yes, sir.
So you better be there.
I will.
Okay. All right. You're all done.
All right. So I'm getting released today.
On this case, I don't know if you have any other holds, but on this case, you're going to be released.
Okay. All right. Thank you. Thank you, Judge.